Welcome to the Branded Assets Podcast, your place for hot takes on business, brands, and billion-dollar gossip. I'm your host, Kate Bouchard. Thanks for being here. Hi, welcome to today's episode. For those of us following along, I am making good on my promise to talk about IP, or intellectual property. It's almost the summer here. The weather is turning. It's starting to get gorgeous and sunny. To be honest, all I want to do is lounge around on my rooftop. But before we get into summer mode and summer state of mind, I wanted to share that we will be taking a bit of a break for summer. So we'll be closing out the very first season of the podcast. In probably about a month's time, I have a couple more episodes coming for you. One of them with Ada for our last Rich Girl rundown of the season. So it's really important to me because I had talked about this in a prior episode and sharing that I get into more detail to loop back around with you and talk about intellectual property. Because intellectual property is one of the things that people only think about when it's already a problem. I've definitely seen that and I've experienced that myself. So when someone copies them, when they receive a cease and desist letter from a different company, when they're fundraising and they realize that their defensibility is basically just storytelling, or even worse, when a lawyer tells them that what they thought they owned, they didn't fully own. In my journey throughout my career, I obviously had heard about IP. And in fact, I'd seen some of these scenarios. I think the first time I saw an entrepreneur close to me go through this was with my girlfriend who I worked with, Courtney. She, kind of by accident, started a scrunchie company. Super cool. I absolutely love her story. And she named it Bunhead. And it started out small. It started as her and I believe it was her mom sewing scrunchies, selling them to friends, and it just kind of became this big thing that got its own legs. And they just had named it Bunhead, and then they ended up getting a cease and desist letter from a company based out of the States that had trademarked Bunhead for specifically that category for scrunchies. And although it wasn't their brand name, I don't believe, or like their website name, it was a sub brand and a product on their site, if I'm remembering correctly. So if she was going to take this thing big and scale up the company, she had to reinvest at this point in a rebrand, renaming of the company and the product from scratch. Bunhead became Super Crush, and Courtney and her team literally crushed it. She recently sold her company and exited from that, but I was just so proud of her. And it was really interesting to see her go through this whole IP process, especially when she kind of became, if you will, like an accidental entrepreneur. I haven't really dealt with any of this through Armature Collective. That work that we have done is brand work, storytelling, marketing systems. But with Loba, I had to actually learn IP in real time. Patents, trademarks, how to file in multiple countries, and timelines that honestly stretched years longer than you would expect them to. So since all of that learning and that journey, I've now sat on multiple expert panels at intellectual property workshops, and I've shared some of these stories about what I've gone through with founders in person, which has truly been an honor and a really fun experience. So in this episode, I want to break it down in a way that actually makes sense for you all here on Branded Assets. I want to talk about what patents and trademarks actually are, what they protect, what they don't, and why even once you have the IP, it doesn't necessarily guarantee enforceability. Are you still buying expensive dresses that you've only ever worn once? Let this be your sign to ditch one-time wear pieces that cost hundreds or thousands and rent an incredible designer dress at the Fitzroy for a fraction of the cost. As Canada's leading dress rental service, the Fitzroy is here to help you look and feel your best without that hefty price tag. No matter what event you're attending, whether it's a gala, red carpet, work event, if you're going to a wedding, or even if you're the bride herself, they have thousands of options available so you can rock a new look at every occasion. I personally rented from the Fitzroy on 2 occasions, both when I was postpartum, and I definitely didn't want to purchase something new in a size that wasn't going to fit me a year later. I rented a gorgeous black dress for a work event, and the other was a sequin beauty for my first ever Looking Glass Reflections gala. Now I'm turning 40 this year, and I anticipate attending a few parties for friends, so I've been browsing the store and deciding what to order. We've got a special discount for Branded Assets listeners. Use Branded Assets at checkout for 15% off your rental. That's code Branded Assets from now through December 31st, 2026, online at fitzroyrentals.com. Plus, they ship Canada-wide. Don't forget to tag me in your photos. I want to see you in your gorgeous looks. Loba was an early stage business, and when you are in the beginnings of a business, intellectual property plays a bit of a different role. IP can buy you time, it can buy you credibility, and it can also buy you leverage, but only if you understand how it works first in the real world. We live in a time and an age where products are copied faster than ever, like everything from dupes to straight up ripoffs. We've seen that brands can scale globally overnight, but only if they have the right access to resources. Manufacturing has definitely become more accessible with things like Alibaba and being able to work remotely. And then, of course, the big shift the last year is that AI is accelerating the imitation of product across like design and copy and concept. So we're kind of in this ironic time where originality, like it's easier to lose and it's also harder to prove. And so this is where IP comes in. IP is not a shield that stops copying completely. Like that's not going to happen given the environment that I just laid out. But more often it's useful as a system and as a strategy. The problem is that most founders assume if I have a patent or if I have a trademark, I'm protected. But that's not exactly how it works. It's more like you now have a legally recognized position that you can defend, but only if you have the time, the money, and the willingness to enforce it. So I'll get more into that, but I think I should start off by just making some definitions here for everyone who may be new to this and do a little bit of a 101. So starting out with patents. I want to share what patents actually are and what they protect. There's two key types that founders should know and then some sub-definitions. The first is a utility patent and the second is a design patent. So utility patents protect the way something works. They protect the novel technology or mechanism, so the function of the product. Its utility specifically, so how it works, what it's made of, or how it's used. Design patents protect how something looks, the shape, the visual design. In Canada, they call these an industrial design patent. So utility patents protect how it works. Design patents protect how something looks. There's also something called a provisional patent. And a provisional patent is basically a filing that says, I'm claiming this idea and I'm locking in a filing date while I continue to develop it. A provisional patent is what I had early on with Loba, and I did this to protect while I built. I did it also to protect myself during a time where I was opening up a wait list, building pre-launch buzz, and gathering pre-orders for sale of the product. So a provisional patent gives you a 12-month window to refine and then formally file. If you miss that deadline of 12 months and you don't file in 12 months' time, you can still file later, but what you do is you lose any benefit of that original early filing date. So then there's something that we hear constantly, used mostly in marketing, and it's the term patent pending. And the term patent pending just means that you've filed for your patent. It does not mean the protection is granted or guaranteed. It just is a signal, mostly to the market and to investors, that you are in the process. But to a point that I was just making earlier about enforceability, people think that a patent means that nobody can copy you. But there's two things that I learned in the process that I think are really important to kind of underline for people. And the first is that with design patents specifically, someone can actually just change the shape slightly of your product, adjust a small functional element, or design around your patent, like design around the claim that you made. They don't have to change much for your patent to no longer hold up. And suddenly, like enforcement becomes quite complicated for you. So, say, for example, you created a product that was, let's say, circular in shape, and then someone comes along and designs a product that does the same thing, that has a similar look and feel to it, but they make it a square, or they make it a triangle, or they change the height of it substantially. They make it just close enough to your design that it feels very similar, but they work around it so it's not enforceable. And then the second thing is that nuance is that there's a reality to enforcing your intellectual property. Like even if you have strong IP, you still need lawyers and time and the money to pay those lawyers and the willingness to go after someone to enforce it. And the truth is that the company with deeper pockets often wins the fight, not necessarily because they're the right one, but because they have access to capital to fight the battle. And so IP is protection, yes, but it's only to a certain extent. However, there are a lot of upsides to it. Like it still matters and it's still important because even with the limitations, IP increases the worth of your company. It signals credibility to the market. Like this is real. This is not just an idea. I'm not just in the concept phases. We've put actual work and money and time into this, which really helps with investors and with partnerships. And it also does create defensibility in those fundraising conversations if you are going to venture or angels to raise. So Overall, IP, it doesn't just protect the product, it helps to strengthen the perception of the company. And that matters a lot, especially in the early stage of business. So if patents are about invention, trademarks are about identity. So these are things like your company name, your product name, your brand, your mark. For Loba, I trademarked the name and the mark across both Canada and the US. And it's quite the process. Like, it actually took much longer than our patent process. Here's something that I think is pretty misunderstood. You cannot just trademark a term or something because it exists in the world or is widely used. Like, if a term is generic or already part of public language in your category, it usually fails what's called the distinctiveness test. So, if your brand name or program name or whatever it is that you're attempting to protect is too vague, or if it's colloquial, there's a lack of distinctiveness and it can't be attributed to one source. So if you're naming your brand or your product in your program, stay away from commonly used terms that are already in the public domain. That's part of why I chose Loba, because I didn't want it to be associated with something that was already existing out there. Here's what the process actually looks like when you're applying for a trademark. So the first step is doing a trademark search. During this process, you're checking to see, is this name already taken? Is it too similar to something in your category? Is it distinctive enough? And is it even worth pursuing? For the trademark search, I worked with a trademark agent. You can also work with a lawyer, and they help assess things like risk, category fit, and things like strategic positioning. The next step is to decide your categories. So this is where it gets strategic. You don't just trademark a name, you trademark that name in classes. And it costs more to add each additional class or category. So you're making a decision like, do I just protect what I'm doing now? So in the case of Loba, do I just protect a pill organizer, or do I protect where I might go in 3 to 5 years? So for Loba, this included thinking about things like, do I want to trademark the term Loba in supplements? What future product lines might we have if things go well? What are potential expansion categories like wellness or home or apparel? There were actually other trademarks and companies called Loba out there. Not a ton. Our trademark search came back fairly clean, but there were a few completely different industry and products. For example, there's actually a line of wood products like wood stains and adhesives, etc., called Loba. And funnily enough, we'd occasionally get emails from customers asking questions about the product to our general contact email address. I guess if people were just guessing at what the email address will be, or, somehow confusing our website URL with theirs. So that would occasionally happen for a product line that's based mostly in the States, I believe. We also had a clothing line named Loba that came up during this process. And they have a big following on Instagram, and influencers, I'm not sure if influencers who they were paying or just organically, would tag us in some of their posts wearing the clothes. So that's how I became aware that there was a Loba clothing line. We all may own our own trademark for Loba, just in different categories. So they didn't purchase, obviously, all of the categories across the board, ridiculous, too expensive, non-strategic, and I didn't either. But it's important to think about what product lines you might move into future. Use the trademark search information and working with your trademark lawyer or agent to come up with what makes the most sense for you to trademark now. You also have to trademark in different jurisdictions by country. So we have trademarks in both Canada and the US, and the filings can be connected, but they are separate filings and separate trademarks. If you're doing IP and trademarks correctly, these aren't just defensive things. They're part of your long-term expansion strategy. And speaking of long-term, I need to share some huge learnings for me that I wasn't aware of going in, and that's the timeline, the reality of the timeline for these things. Like, this is something that most people underestimate and that I just was not aware of. So I thought to help demonstrate this, I took a look back, and I'm going to share some specific dates with listeners so that you can get a sense of what to expect. Here's what I pulled from Loba's record. So our patent, we did do the provisional patent. I filed that in May of 2021. I did that prior to creating our waitlist and opening pre-sales. This was like quite early on, because it wasn't until 2022 that we launched pre-sales on our website. So that bought me the 12 months, right? So that I could maintain that early filing date. It wasn't until March 2022 that we filed the design patent in Canada. So within that 12-month framework, we didn't get our design patent registered in Canada. So we didn't hear back and have the formal registration process until October 2023. So that is about 2.5 years from when we initially filed for the provisional patent. And trademarks are even longer. In November 2020, I conducted my first trademark search using my trademark agent. In March 2021, we filed in Canada. And then in August 2021, we filed in the US. Canada and US have an agreement so that even though we filed in the US in August, it backdates to the Canadian March file date, which is super helpful. Once you file the trademark, so at this point, we actually could begin using TM on everything. So you'll see people's logos with like TM kind of small in the corner. You can start using that once you file for the trademark. So that was March 2021, filed in Canada, August 2021, filed in the US. In March 2025, 4 years later, our trademark was officially registered in Canada. That's when we could begin using the little R in place of the TM next to our company name. And then it took an additional year, so 5 years after the original filing date, for us to have the trademark registered in the US. 5 years, start to finish. By March 2026, obviously, that's just a few months ago, we'd already wound up the company. During all of that time, you're already building, you're already selling, you're already operating. And in fact, as I mentioned, I'd stopped operations on Loba before we got that final US trademark registration. So you can see that nothing about IP is fast. It needs to be rooted in strategy as a result. It's an ongoing system that sits underneath your business. It's happening in the background. And the biggest misconception is thinking once it's filed, you're protected. Because that's not the case. It's really more like once it's filed, you've entered the system. You have structure, you have that structure, but you don't have the certainty of it. And I think that really says so much about business right now, right? Ideas are not a moat. Execution is happening so fast. Copying is super easy. Distribution is everything. And the question becomes, can I protect this long enough to actually build real value in it? So we're not just protecting our ideas, but we're protecting the time to build value. So I guess, some implication for founders out there right now who may be listening to this is that if you're building something right now, start thinking about it. Because as demonstrated in my example of Loba, it's a long ass process. Think about what is actually protectable here. In your case, is it the name? Is it the brand? Is it the product? Is it the system that you have? Is it the method? Is it the utility or the design? Where is that true value? And where do you actually need the protection versus where are you possibly going to be overinvesting money and resources if you try to see something through that's not going to come to fruition? Not everything out there deserves a patent or a trademark. There's lots that I do with Armature, with my personal creative projects, hell, with this podcast, right? That doesn't make sense for me to trademark at the moment. But in my opinion, every serious brand should at least, and founder should at least understand these things, understand patents, trademarks, and IP, even on a 101 level early on, so that you're making decisions that are strategic rather than from a place of just not being informed. And I hope that this podcast episode has helped you with that 101, and that if it is applicable to you, that you go away and do some digging and some research just to inform yourself even further. But if there's one thing that I want you to take away from this episode, it's that IP is not only about preventing copying. It's about giving yourself that time, giving yourself that leverage and that credibility while you build. And, most founders either just ignore it completely or overestimate what it actually protects. So if you can go away from this episode understanding that, I think you're ahead of the game already. Okay, so that's it for today. I hope you found this useful. Share this episode with another founder who might be building something or maybe toying around with an idea in the conceptual phase right now. Follow Branded Assets on Instagram or TikTok for more breakdowns like this. And if you want, DM me about your business name or what you're building, and I'll tell you what IP questions you should be asking first and who to talk to if I can help. Okay, thanks. Talk soon. That's a wrap on today's episode of Branded Assets. Power looks better when women are in the room, so thanks for listening. If you like what you heard, follow the show, share it with a friend, and join us on Instagram at Branded Assets. We're just getting started. I'm Kate Bouchard. See you next time.